All right, sir, I'm detecting a bit of an attitude, and I've had a bit of problem with you all day long. I'd suggest you kind of take a deep breath and try to get rid of the attitude, because then if you don't, you may cause me to have to get an attitude too. So,
well, likewise, take that deep breath, do the same thing. You know what I mean?
Excuse me?
I said same, do the same thing. Take that deep breath. Goose fraba.
All right, Mr. Phillips, do you know what my title is?
I do, but that doesn't give you the right to belittle me or anybody else in your court. You know,
All right,
you have a code of conduct.
I am finding your conduct contemptuous because you're interfering and disrespecting the process and the court. You are hereby fined for direct contempt of court, $100 cash payable in 1 week to the clerk of the district court.
That's fine.
And if I have any more problem with you, it's going to go up a little bit more. And if I have any more problem with you, you can go to jail over it.
I know this is being recorded, so I would like a copy of this because I'm going to take this to an attorney. That's fine.
$500 cash for direct court, and I am ordering you to surrender yourself by 2:30 today to the Butler County District Court.
I cannot do that.
Well, then I'll send a sheriff out to get you.
You have been delaying the court the whole time.
All right, I've given you my order. Disconnect him from the call. He better be here. The sheriff will go out.
I will not be there.
You refuse to tell me your address?
It is none of your business. You will be informed through my attorney.
I think we're ready for William Wayne Phillips and Attorney Zolator.
Okay, let me get them in here.
All right, thank you. All right, we are on the record in 2024 TR 1376, State of Kansas versus William Wayne Phillips. Please announce appearances.
Jared McGeer on behalf of the state.
And please, court, Mr. Williams appears in person with counsel Kevin Zolator.
Hang on.
This matter is set for bench trial today. And Mr. Regier, I see, has subpoenaed Trooper Andrew Lieber, who has been with us since 1:30. Now then, Mr. Zolator, does your client still wish to exercise his right to a trial?
No, Your Honor, we're requesting a continuance.
And for what reason?
We were just recently retained, I think, a few weeks ago.
Well, this case originated with some kind of traffic stop May 21st of 2024. The defendant had first appearance August 14th of 24. He appeared before Judge Rickey in custody September 11th, 24. He appeared before Judge Lee September 20th, 2024. Each time, this time he requested a continuance and the Chief Judge Rickey denied it. No, I'm sorry. Judge Lee denied it and set it for bench trial today before me. That was September 20th, the trial was set. The defendant told me back on August 14th he was hiring an attorney, which he has. And I show an entry of appearance filed October 24th. We're set for trial on charges of speeding 86 and a 65. We are also set for trial. Let me look at the amended complaint filed August 1st, see if there's anything still remaining. Count 2, driving while suspended after a prior conviction, a Class A misdemeanor. Mr. Regier, your response?
Your Honor, for the sole purpose of it, well, Your Honor, forgive me, Your Honor. I will, if I may, respectfully request 30 seconds.
Granted.
Thank you, Your Honor.
Now, your response to the request for continuance, Mr. Regier.
Your Honor, for the sole purpose, if indeed the continuance is being requested, other than recently retained, perhaps there are some other reasons, which I'm sure counsel can defer to the court better than I can. I would advise the court, in accordance with my duty of candor as an officer of the court, that I am not aware if discovery has been provided in this case. Certainly, legally, that is something counsel for the defense would be entitled to. However, to refresh the court's recollection.
You don't have to refresh my recollection, counsel. He entered his appearance October 24th, 2024. You can't tell me if you sent him discovery?
Your Honor, for my understanding is that issue is still outstanding, so.
I don't want it outstanding. I want you to check your file and tell me if he's had discovery and when he got it.
Your Honor.
Or, Mr. Zolotor, you're an officer of the court. Do you have discovery and when did you get it?
Your Honor, I do not have discovery in my file with me, but I am not going to advise the court that I've not received it without checking the office file, which I can pull up now.
Meanwhile, Mr. Regier, if you have an answer from your end, I'd appreciate that.
And while I look, Judge, I think Mr. Regier was referencing other reasons. Obviously, we were just recently retained. I haven't had an ability to discuss with Mr. Regier possible resolution short of a trial. But, you know, all that I thought was somewhat implied in my statement that we were just recently retained. I don't think we've had sufficient time to do all the things normally that are done before trial. But I am pulling it up now and I can tell you if we've received discovery or not. It does not look like on my end, Your Honor, we have received discovery.
Mr. Regier, how long does it take your office to get discovery? I mean, October 24th, he requested it, and it's now November, 13th? How much longer do you think you'll need to get that to him by computer?
Your Honor, if under these circumstances, the state does not object to this matter being set over.
Well, my question was, and I don't know if Mr. Zolotor is the office attorney, I don't think he is, but we've had this issue before, and I have repeatedly ordered discovery go to the attorney, and what was it, 128 day? No. I can't remember the number of days that your office, even though I had ordered him multiple times to receive that, had still not sent him full discovery. I hope we're not going to get caught in another one of those situations where I order it and it's not done. And I'm concerned that now I'm hearing that after all this time, he hadn't even had it sent to him. So do you have any assurance, better than what we've had in that other case, that you'll send it to him, Mr. Regier? I frankly don't recall who the attorney was that we were having that problem.
Yeah, and from my end, Your Honor, and I've never had problems with Mr. Regier getting me discovery. My request was not based on, and I understand the court's frustration. I'm not trying to play both sides. We haven't had it. I wasn't complaining about that at this time. Frankly, I don't think a trial is going to be necessary if I get discovery and I'm able to talk to Mr. Regier, be more efficient that way. So that's my request. And I don't have any prior, I don't know what case you're referring to, but I would expect that I would get it in a short amount of time.
Well, Mr. Regier, do you recall which case I'm talking about?
Your Honor, not by number, although based off my records, it would appear that my office has communicated with Mr. Zolotor's office as recently as within the last 24 hours on the outstanding discovery issue. I would anticipate that being resolved in a timely fashion.
So we've had this bench trial set all this time, and they finally had a communication with him about discovery the evening before. Yes, I am frustrated. This is not the way cases are handled or to be handled. Particularly in this case, where the defendant has been told by multiple judges that we would have a trial. Judge Rickey said he said it. Let me get to my judge. Judge Rickey told him he was setting it for jury trial with me, and no, I strike that. Judge Lee told him it was going to be set for jury trial. This has just been, he's seen 3 judges over the course of a number of months. He's told each of us he was going to hire his attorney. And now we come in here after he was specifically told to be ready to go to trial today, and he's not. And The reason you all know, I'm sure, that I am expressing frustration with this defendant is because he cannot do what courts tell him to do, according to my experience with him. And let's put that camera over there a little bit further so he can participate in these hearings. This defendant has told me in no uncertain ways that he doesn't have to give me what I ask for. He won't do it. He does not have to appear when I tell him to, and he has told me he won't appear when I tell him to. He has called me names, referred to me in a negative light, and he just does not seem to appreciate the judicial authority of me, of Chief Judge Rickey, or Judge Lee. He does not do anything any of us tell him to do, except I am impressed he shows up today with an attorney, one of which I know is very respectable and does do what he says he's going to do. So we are making progress.
To that end, Your Honor, at some point, my client would like to address you.
The other issue?
No, to address you.
All right. Well, at this time, I will grant the continuance at the defendant's request, but it's going to be the only trial continuance because I feel like this defendant has just been trampling over the judicial system for months now, just literally trampling over it. And I don't know, Mr. Zolator, if you've seen the videos from earlier hearings, but if you haven't, you really need to.
We have.
All right. This case will be continued. When's our next bench trial? Or does he want a jury trial? I have a jury trial in February.
Your Honor, I haven't discussed that with him. I am representing to the court that I do not think a trial will be necessary. If I must elect, I will have to go with a jury trial at this time because I have not talked to him about waiving his constitutional right, which I think is guaranteed because it's a Class A misdemeanor, not a Class B. If we set this for a status, I think we can probably get this resolved. I can't guarantee that. If you don't want to do that, I would request the jury trial set in February.
I will set it for jury trial, but you'll need, of course, make the written demand and so forth. Because I just don't want to let him, of course, like I said, he's got you now, and you're not prone to play the games that he has. So, all right. When's our next available status conference? Not until January?
And I apologize, Your Honor. I'm not available that date either.
Okay.
But if we can resolve this, I certainly will try to get a plea date before then.
Okay. Well, let's set it for pretrial February 3rd, 2025 at 9 a.m. and that will be by Zoom. The pretrial will be by Zoom. But of course, the bench trial or the jury trial that I'm setting will be February 5th and 6th, and that will be live at the courthouse. And the defendant, as condition of bond, is ordered to appear both dates and time. He needs to appear at the courthouse. I cannot trust him not to appear at the courthouse. So make sure he's here at least at the courthouse. Then if you want to be with him in person, that's fine too. Okay, so continued on your bond with those conditions. Anything else before we get to the other point at hand?
No, that's fine, Your Honor.
All right. Now, the defendant was found in contempt multiple times and still wouldn't quit disrespecting and disobeying the court until eventually he was ordered to reappear later the same day in person at 2:30 p.m. He told me he wasn't going to. He wouldn't tell me where he lived, where he worked, blatantly refused to answer any questions of his whereabouts or anything I asked of him. He continued to smoke during the Zoom, even though he'd been told not to. He continued to eat and take an enormous amount of drinks. And he continued to get in and out of his truck and walk around the job site, take his hard hat on, take it off, walk all about, all during other defendants' hearings. And then when his case was called, that's when he started becoming blatantly, verbally disrespectful and telling the court how to do its job and not do its job. Throughout the docket, he was highly disrespectful and disruptive. He would talk over the court. He would make rude, personal, insulting, and disrespectful comments about and to the